Impact of influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris, Seton Tucker, Impact of Influence. You can find us on Facebook. Join in the conversation. And we continue with the story of the Rose Petal murder and the trial, which ended up in the conviction of 33-year-old Zachary David Hughes. But there's many questions from that. Get to that in a second. Want to make sure that you take care of our sponsors. So we are part of the Evergreen Podcast Company and the YouTube channel that we're getting rolling. I'd love to have more subscribers to that. Rate, share, and take care of that. All right, Seton, bring in our wise guest.
We are bringing in my dad. He is a graduate of Penn Law School, a former federal court law clerk, and a professor at Temple University in Philadelphia.
Hello, Matt.
Hey, how you doing? Nice to see you guys.
Nice to see you again. So many questions and things that laymen like Seton and I have not seen before in trial. So we are going to go through some of those. Where do you want to start with, Professor?
Well, I wanted to start out talking about this article written by Jen Woods with Fitz News, and she interviewed an alternate juror. And I just found this article so fascinating because it really kind of gave a behind the scenes look of what happened with these jurors. So one of the things this juror says is that they didn't know the whole truth until the conclusion of the trial, that they got some hints of what may have been going on, but they did abide by the judge's order not to read any media coverage and to disregard any references to child sex abuse during their deliberations. But then the juror says that he didn't believe that Hughes got a fair trial after the conclusion of this trial and he found out all the stuff about the child pornography. He said that they heard some things that it probably was difficult to get out of their mind, but I wanted to get your opinion, Dad, of what you think of this juror's assessments.
Yeah, it's what we have been talking about all podcast. That the reason why the defense wanted to get the evidence information in about porno and child abuse and bestiality is because that, in my view, most likely would have resulted in an acquittal or at least a hung jury, but probably an acquittal.
The juror says that. The juror says that he thinks that,
Yeah.
if the jurors all knew this stuff, that the outcome may likely have been different.
Yeah, and I think that obviously the prosecution knew that, and that's why they fought so hard, and the judge generally agreed with them to limit what the defense could say or do or get into. And obviously, from the defense point of view, they knew that if this came in, what the result would be. I mean, the real issue, I think, probably from the court's point of view and as a matter of law, is that, at the time he killed her, this information was not directly known. And that therefore, in terms of a process, you simply can't go out and kill somebody on a suspicion. And you shouldn't be allowed to kill anybody anyways, but you shouldn't be allowed to kill anybody on a suspicion on the basis that somehow I was saving a young child from immediate and irreparable harm and danger and stuff like that.
So probably I'm thinking that, if by chance Hughes is successful in his appeal where he is able to get a new trial and the judge does allow some of this stuff to come in, it would definitely change the prosecution's strategy because they would say, well, wait a second. None of these pictures were actually known until after the death of Christina Parcell. Yes, there were suspicions, but definitely not known. So they would really want to hammer that in, I would think. What do you think?
I think you're right. And I think, most likely if the appellate court reversed and said that information should have came in or the evidence should have came in, I think that the prosecution may very well not retry the case.
Yeah.
Or if they do, they wouldn't try it on murder. They may try it on harassment or some of the other charge that he was convicted on.
This juror, they didn't find the DNA evidence compelling.
Oh yeah, that was crazy to me. The one juror said that the DNA put Hughes in her, was with her at some point, but he was confused why there wasn't more DNA on the bike and on gloves and other things they found. But I would have thought when we heard it originally, we're like,
I
this is a
think it
slam
was,
dunk.
yeah, and the juror didn't think that. The juror also said that he found Hughes unlikable on the stand, and talks about the maybe the lack of emotion that he showed while he was testifying. Uh, and of course, we know that Hughes was found guilty. Uh, do you think it was a mistake for him to testify? Is it always a bad idea for a defendant to testify?
Not necessarily always a bad idea, but generally speaking, in criminal cases, you rarely see a defendant testify. Um, and the reason is some of the things that you said, that, the juries, look at the witnesses. They try to identify with the witnesses. They try to look at the credibility of the witnesses. Um, I saw some what you guys had on your podcast about his testimony and how he responded and what he did. And it was pretty clear to me that he was pretty cold and I don't want to say indifferent, but not very compassionate the way he presented himself, and presented himself in a way where if you didn't know about the other information that was going on in the case, you could very well decide he's a very unlikable guy. He stabbed over 30 times. He did it in a brutal way. And it just doesn't help his case out. So to answer your question, I generally, if in a criminal case, it's not a good idea for the defendant to testify. Sometimes it is, but generally not. I mean, you saw what happened in the Murdoch case, for example.
Right.
It obviously didn't help him to testify. Um, I think just to add on to that briefly, that generally, I think what happens is that during the course of the case, it's that's why the judge asked the defendant, you have the right to testify even if your counsel doesn't want you to. And the reason is they want to give somebody the opportunity to say their piece. Sometimes you have people who just feel that they can somehow get up there and persuade people and do it that way.
I
Right.
think that's
Other
what Murdoch thought for
Definitely what
sure.
I thought, yeah.
Yeah.
Yeah, other times, the both he and the lawyer decide that, hey, this is going badly. You need to get on the stand and see if you can persuade the jury
Well,
otherwise.
one
And I
thing that
think that in this case, probably the DNA evidence was such where the lawyer and he believed that he was cooked unless he got on the stand.
Well, I thought it would be he'd be on the stand because this whole idea, and we'll get more into it in a minute, if it was done without malice, kind of needs an explanation, right? If you just without
well,
someone telling the story and you just say, "Hey, he just did it for these cloudy reasons, which we can't talk about, and he has no malice,"
yeah,
kind of hard to tell the story without the guy
well,
who did it, right?
we'll
Right.
talk about the delaying of the opening statement, but I don't know that that was totally the plan that they were going in. Maybe that's why they delayed the opening statement. But one thing that Jen Wood told me personally was that this juror also said that they all talked about it ahead of time, and they did not want to show emotion. They wanted to keep so that they weren't really giving away clues to how they were leaning, and
You
that
mean what you have to explain that? You're
the,
saying,
the jurors themselves were hard to read because they were not they intentionally said let's keep our opinions to ourselves. Everyone just don't show any emotion on your face during
okay.
testimony. So I think that in particular this jury was maybe difficult to read by the defense and the state. They weren't sure.
Yeah, one comment I'd make from, doing a number of jury trials is that what I have found is that our jury system is very good. And that what you find is that the group of them is much better than any one individual. And as a result of that, what you're talking about is what occurred here. They all got together and everybody, for lack of a good word, sobered up in terms of their views and what they wanted to do. So they all basically agreed to do it the right way. And that makes perfect sense to me. I've seen that in a bunch of cases. And that's the way it should be.
Well, there was a comment that the juror made that had talked to Fitz News that the door was open a little bit when they were pulled out of court with some sort of proper testimony of
No,
sorts.
it wasn't. It was when the judge. It was after lunch. The judge had, before the jury was coming in, the judge was having a conversation with Zachary Hughes, like, "Hey, I've already instructed you. You cannot testify about this child sexual abuse stuff." And this is the part the juror says that he heard was he said, "Well, I put my hand on the Bible and said to tell the whole truth, so I'm confused." And the juror in this article says, well, I mean, I agree with that. So anyway, would the fact that the jury heard some information that they were not supposed to hear because the door was not entirely closed, would this be something that would be an appellate issue?
Even though he was convicted.
It could be, but I think that is most likely harmless, error. Remember, we went through all that,
Mhm.
in the Murdoch case and the fee case and all the stuff that went on there, particularly in the Murdoch case. And so that, if they hear something that is somewhat benign, or something that really doesn't influence or affect their deliberation or their verdict, that's really harmless error, and that's not really going to result in reversible error. So I don't think the way you just explained it to me would be enough to get it reversed on that basis.
Okay. Yeah, because the juror said that they agreed. I mean, this was an alternate, but this juror said that they agreed with what the defendant said on the stand, that yes, he agreed to tell the whole truth. So, that was actually in his favor, but then Hughes was ultimately found guilty. So, I don't know. You're right. I think it may not have influence to the outcome in any way.
I think before we get to the question about the juror reenacting the thing, we need to know this malice idea.
Yes.
Okay, so I've never heard this. Seton's never heard this. I don't know how often it happens that someone is charged with murder and they go, "Yeah, I did it, but there was no malice." I imagine that's not very common, right?
Well, no, I mean, well, if somebody, let's break it down a little bit. If somebody kills somebody in self-defense, for example,
Oh yeah,
obviously they didn't have any malice or intent to kill the person. Something happened where they had to react quickly and unfortunately killed the other person. And that is a defense that's there. Malice really goes to, was there some sort of forethought or intention that went into the act that resulted in the killing? And that's what they look at here. Now, clearly, there was some forethought on his part to go
yeah.
and kill her, because he did, and he killed her in a very brutal way. So without the other information coming in, where they could try to make some other defense about how he was trying to, save a child, that it's very tough for the defense to counter the suggestion that there wasn't malice involved here.
So and would oftentimes the malice, like, is that what you would do? Let's say a car crash or something, and you move it to manslaughter or something like that. Is that kind of a similar thing?
Or someone is pointing a gun with you, you struggle it away, and
Well, that's self-defense kind
yeah,
of
yeah.
though. But I'm saying
Yeah,
like an accidental
right. And
death.
that's why there's different counts of murder, like involuntary manslaughter, second degree murder. It all goes to the level of intent and what was going on. First degree is obviously the highest, and that requires someone to have some forethought and knowledge or intent to kill the person.
Now, it said they kept coming back to anger, and both sides were saying he had anger in his heart. He didn't
Yeah.
have anger. He wasn't. Does anger have anything to do with the malice?
Well, it depends upon the case, obviously. I mean,
Yeah,
here,
You have to have the intent to do harm, right?
yeah, and here he clearly had intent to do harm.
right.
So the question was there any justification, for what he did here? And that's what it's going to come down to.
Now,
Uh,
this juror that Jen Wood interviewed was an alternate, so they were not. This person was not in the deliberations, but I guess afterwards these jurors had like a text thread, and the juror says that I guess two of the jurors were grappling with this malice concept, and he describes the situation how another one of the jurors reenacted the stabbing, and pounded on the table, and she was stabbed 35 times. Do you think it's an uphill battle to prove that there was no malice when she was stabbed 35 times?
it certainly makes it more compelling that there was malice. I agree with you there. And what it shows, is definitely an intent. I mean, what the real issue comes down to here is, as we started talking about at the beginning, is that, in this particular case, he killed her based upon his belief, without really firm evidence or knowledge, that she was abusing the child in various ways, involved in other activities and stuff like that. Fact he didn't have hard evidence there I understand where the judge was coming from. I understand why the defense was trying to prevent information coming in and why they tried the case they did. And quite frankly, if that was all there was, in this case, even though he might not like the result, maybe the verdict should change. If there was an opening of the door like there was in a Murdoch case, for example, and they could have gotten into that information, that would have made more sense. So, for example, you asked me in one of your earlier questions about the opening statements. And it was pretty clear to me that, well, first of all, I've never had a case where I've not made an opening statement as a plaintiff or defendant. That's just
Wow.
something you do. And the reason why is that what I found over years of trying cases is that the most important part usually of a case is the opening statement. Because what you're doing is you're telling your story and you're explaining to the jury what happened and why you're right. And you have to develop up a bit of credibility. They have to see you believe in your story. They have to see a little passion from the lawyer who's presenting it to them. And that based upon that, what takes place, what I've generally seen in the many cases I've tried, is that in the first several days of the trial, the first several witnesses, if what you told the jury in the opening statement, whether or not you're the plaintiff or defendant, seems to back that up, you won the case unless something goes haywire. So for that reason, generally, I do, and I think a lot of other people, make opening statements. Now, here, and by the way, I've seen really good trial lawyers who don't consistently. What they do is they wait to their case, and they've had good luck, doing it that way. But here, I think what was going on was that they were trying to figure and see if they could find some way to get all that evidence or information into the record before the jury. And so before they made their opening statement, they wanted to see what the case was going to flush out to be before they got to the defense. And then once they got to the defense, they would make their opening statement and present it that way. So I see where they're coming from and why they did it that way. And I think they realized that the only way they were going to win this case is if that information, got before the jury. And based upon the Fitz News article and Ms. Wood's article that you mentioned, it's pretty clear that the jurors would have found him not guilty if they knew that information.
Well, I have a question about the fact that they allowed in, and granted it, maybe it was the door was open because of the harassment, but they let in the fact that she allegedly had these nude photos, allegedly part of this escort service, all of that about what could be considered character or whatnot, but not the child endangerment and child sexploitation issues. It kind of seems like if you're going to let in one, don't you let them all in? But I'm not an attorney. I don't know.
Well, I think the distinction is that, that information was known by Hughes and known by Mr. Mello and others before the murder was committed. So that was information that was out there and known, and depending upon relevancy, could be presented and given to them. The difference here is that no one knew the extent of it. No one knew about what was going on with the child. No one knew about the photographs. No one knew about the bestiality. No one really knew about that at the time. And even though there were some reports to the police, it came across as more of the, reaching out and trying to create issues to get child custody rather than firm, hard information that they had. So that what it really comes down to, is the fact that you have to live what was known by the people at the time the jury, at the time the murder was committed. At the time the murder was committed, they didn't have that information or facts. Now, the one
They had
issue
arrested
that,
somebody on it. They had arrested charges, but they didn't have that case has not been tried, so the facts aren't complete.
well, they got all the evidence,
Yeah.
and so, with all the evidence and tapes and thumb drives and photos and stuff like that they have, it's pretty clear. that was what was going on, and that could have been presented.
But
I
so, but
think the
Hughes
better
is
issue, just one more thing on the better issue that could have been presented is something that Seton texted me the other day, which is that I think that, did they open the door by having the guardian ad litem testify about her character in various ways? Oh, yes, I would have ruled in her favor. Well,
Right.
okay, would you have ruled in her favor if you knew what was going on? Obviously not. So I think that that's the one appellate issue that to be able to grasp onto and hold on to and get to.
right because she testified,
To character.
to character. That was, and there was a well, there were two. There was that with the GLA where I mean, it was like they're testifying about her good character too, because during her testimony, she describes she thought the child was thriving and doing so great. And she would, with the information she had then, and she emphasized that word, she would have recommended Parcell as the person the child would stay with. That's presenting good evidence. Does that play a factor at all? Because if they presented good evidence about her, does that mean they could also then present bad
Which
evidence?
which just relates to the Murdoch trial in a way too, right? Because that, yeah,
Exactly right. And that's what really opened the door and got him convicted because of the fact that they opened up that sort of evidence
about
in some of
character.
the questions of some of the witnesses
Mhm.
in the Murdoch case. But I think that's right. I think that's the best argument that I've heard on appeal yet. The
Well,
other,
there was
the other
another opening door situation though too. There was one other one when Bradley Post was on the stand during his proffer testimony. His attorney was there, and he eventually pleads the fifth. But before he does, he's asked the question: "Isn't it true that you worked with Miss Parcell to create, and distribute child pornography?" And before he asserted his Fifth Amendment right, he says, "No, no." Now this is just proffer testimony, but do you feel that that opened the door in any way?
No, because it was being offered in the proffer outside the view of the jury.
Okay.
I so the guardian ad litem when she's saying that she would have ruled for the mom and all that. The I would think then the defense should have the ability to cross her and say, well, did you know this? Did you know that? Did you know that? Because the door is open. But do they have to say right then, this is Judge, I want to tell you that I'm going to appeal this particular thing? Do they have to announce it then, or can they announce later?
They don't have to tell the judge what they're appealing. They can just
Okay.
simply ask the questions which the judge shut them down on.
Okay.
Well,
Yeah.
I want to backtrack to one thing. So when the judge made the decision to not allow any of this child abuse, sexual abuse stuff to come in, he cited juror confusion. Can you explain what juror confusion is and how you think that played into the judge's decision?
Yeah, I mean, I think what the judge was doing was making a bit of a nuanced argument. And by that, I mean, what the judge was saying was that, this is a straightforward case where the guy showed up, got into the house and stabbed her 35 times and killed her in a brutal way. That he did not know at the time that she was involved in child porn and all the other stuff that she was involved in. Therefore, by putting it all in, sort of confuses the jury in terms of whether or not he's guilty of murder or not. And what the judge is really saying is that he's guilty of murder based upon the fact that he showed up, killed her the way he did, and that evidence or information that came out afterwards was not known to him.
And could that add more stuff to the jury charges, which would also, because jury charges, I think these jurors, they had questions. They came back and asked about the definition, if murder required malice. So if you have all these other things that come in, does that also complicate jury charges?
Yes, because then you got to try. You shouldn't be considering this. You shouldn't be considering that. You should take this for this. You can only consider her future conduct to decide, her credibility. You can't decide. You can't take that into consideration in terms of whether or not he murdered her. That's the sort of thing the judge would have to do, which would be awful complicated and cumbersome and confusing.
Now, but as a lay person, one of the first things I question is, okay, you have the ability to say, I did this, but without malice. But he doesn't get to tell the story of why it was malice. So
Right.
it's like, to me, from the outside looking in, not knowing the intricacies of law, he is unable to tell his full story as to why he did it and why it was without malice. Am I missing something there?
No, I think you're on the mark, Matt. In fact, what I'd add to that though is the fact he obviously didn't come across well. So you had somebody who was not a good witness getting up there and basically saying he killed her in the way he killed her. And, gee whiz, he didn't really, he was struggling to kill her, but he did kill her. And he didn't use his gun for whatever reason. He couldn't hit her over the head for whatever reason.
Yeah.
And then stabbed her 35 times and dragged her body away from the door or window so people couldn't see it. I mean, all those things are not really good for him unless you get the full context is what you're really saying of why he murdered her, and he was not allowed to get into that
So that sounds,
because he
is that
didn't
an
know
appeal
that.
right there? Do you think is this going to be appealed?
Well, yeah, the whole thing's going to be appealed, but I think what it's going to come down to is that if this information had come out, it's clear there would have been an acquittal, is what we're hearing from the news reports and others out there, and that was sort of my view beforehand. I think that they have a argument that on the character stuff that it opened up. Is that an ironclad argument? No, but it's an argument. The question is whether the appellate court is going to feel that in this case, in light of all the other information that comes out, they're going to try to find a way to reverse and open it up in some way.
Well, it was interesting on the state when they did the cross of Zachary Hughes, they only asked one question. And I heard that this was actually Walt Wilkins' father was formerly a solicitor, and he had a case that kind of where he just crossed the witness with one question. So I think it might have been a nod to his dad. But they said basically after you killed him and you dragged her body, did you drag her by the arm or wrist, I don't know, or
Yeah.
the leg or the ankle? I can't remember exactly how it was phrased, but just ask that one question that seemed to be pretty powerful. What did you think about that strategy?
I think they knew that if they kept him on the stand, he was going to continue to try to blurt out information, which might get him acquitted. So they decided that they needed to, because he took the stand, the jury's expecting a cross-examination. They were figuring, what can we do that's going to sound dramatic? And what they decided was, well, we'll ask how he moved the body, and that
Yeah.
was the dramatic way of asking it and closing in that particular way. I had a case once that I was doing, was involved, someone asked me to do it as a favor for a young man who was arrested up at Gettysburg College. And the allegation was he showed up a party and he was wielding a knife or something like that. And so the police came and arrested him and took him away. He happened to be a African American student who was an athlete at the school. And so I got a call from the coach, would I help him out? So what I did is I went to the hearing and I did, it's interesting, it was in Gettysburg, what Abe Lincoln used to do, which is, after the police officer and everybody testified, I got up and I asked one question. And the question was, you charged him under this statute? He says, yes, I did. Sat down. The judge is looking at me. He says, why'd you say that? And I said, because he can't get convicted under the statute for what happened here, under the facts that they're alleging. And the judge says, you're absolutely right, and dismissed the charges.
Oh, wow.
So there are ways
Right.
you can do that sort of stuff that is effective.
Right. Right.
But I mean,
Um,
it's sort of a gutsy thing to do. But I think the prosecution had any other choice in this case if they're going to get a conviction. And what it's going to come down to is on appeal is whether or not the appellate court is feeling that, yeah, we sort of get it. He would have been acquitted if this information was out there. Should we find a way to reverse it and send it back? That's what it's going to come down to.
One thing that was really interesting, this is very legal ease to me, but when they were talking about the jury charges before the jury came in, the state wanted to take out, because of some of Hughes's testimony from the definition of malice, he wanted to take out the terms without just cause or excuse. So they took that out of the actual legal definition of malice. And the defense argued back, just because you didn't like his testimony doesn't mean that you can change the legal definition of malice. So I don't know. It seems like that could potentially be something that comes up on appeal. Do you have any thoughts on that?
Yeah, I mean, not being a licensed South Carolina lawyer, and studying all their case law on this, notwithstanding that, it makes sense to me that that would be a good appellate issue. Why should you be able to narrow or change the definition of malice to a jury? Because obviously they knew that didn't help the state. So I think that could be a good appellate issue.
Does the defense, is there any obligation to tell the state, the prosecutors, that we're going to admit he did it, but we're doing this malice angle, or can they just spring that when they spring that?
You don't have to tell the state anything. You
Okay,
can simply
state
get
doesn't
up and
tell you.
present your case. Yeah.
Okay, this is just a generic question. When the defense says they're not going to make an opening statement, does that mean they can make it at some point during the trial? Do they have to announce when they're going to make it, or is it done? They can't make one
They can make one when they put on a defense.
right before they start their.
Yeah, that's what they did in
That's
this
what they
case.
did. But I don't know. I didn't know if they were allowed to not do one at all, or is that,
Oh,
or if they could do it earlier or later. But that's when they have to do it, right then.
Exactly.
Okay.
Exactly.
The is the state ever allowed to not do an opening?
Yeah, they could do it the same way. I've never seen it happen.
Yeah,
well,
that'd
yeah.
be weird.
Why would you?
I don't know. I don't know, but I didn't even know it's even a thing that they are like, we pass. We'll let the defense do theirs first.
I mean, because theoretically, Matt, you could have the defense the prosecution get up there and say, "We're going to prove he's guilty," and sit down.
Yeah, yeah, right.
Usually people like to get up there though and tell a little bit what the story's going to be, what the evidence is going to be, how the case is going to proceed, something about it.
Especially they go first, so they already know their strategy.
Right.
The defense doesn't, may not know what they're going to do yet. In this case, it sounded like they weren't exactly sure.
I do want to ask this question. If Hughes is for some reason successful in getting an appeal, and now we know that he didn't really do the greatest job playing to this particular jury, obviously they would coach him and try to make him show maybe possibly more emotion when he's describing this planning and committing this killing. Does he have to take the stand in the second
No,
one?
no. He
Everything
doesn't
starts from
have to.
scratch.
Yeah, you start from scratch. He does not have to take the stand. And as I said, I'm not sure the state would retry him on murder. They might, retry him on harassment. There may be some issues about, the judge holding him in contempt of court. There may be some more proceedings on that. But I don't think they're going to retry him on murder if the court sends it back and this information can come in.
See, I got the impression that they would, but I don't know. Well, they know there's a lot,
Yeah.
Solicitor's an elected position. So I think that these guys want to have the feathers in their cap to get these convictions.
But maybe they wouldn't get a conviction, especially let's assume that Bradley Post is convicted of a whole bunch of things
And then
prior to the next trial.
That's true.
And they don't want to have losses, and they don't want to have a trial where they're trying to convict somebody who theoretically was saving a child from child abuse and sexual abuse.
And
True.
Speaking to many of the community members when I was there for the trial, a lot of them were very conflicted, feeling that way, that they didn't necessarily think that he should, it should be a murder,
For the people who
trial.
knew or believed that she was this awful person.
That he did this good deed by saving this child.
Yeah. That's why it'd be hard to get a conviction, right? If they knew everybody knew everything.
Yeah. Now, with all that said, if you take out the the issues we talked about, the guardian ad litem and the character evidence about Parcell, if you take all that out, and that was not in the case, and all you had was somebody who sort of believed this person was up to no good and went in and killed him, that should be murder and he should have been convicted.
Right. That's vigilante
And
justice.
yeah, yeah. And I think that what's shaping everybody else's view right now is the fact that they knew how evil she really was and how evil the people around her
Or
were.
they believed that at least. Yeah.
Yeah, yeah. And so as a result of that, everybody now is saying, wow, this guy should not have been convicted of murder. Um, and and all I can say to that is, but for the character and other information and all the views around this is horrible stuff that they did, if he did kill her.
I had
Uh,
plenty of other people say that too. I have plenty of other people who said
It's kind of split.
if it's split, that if even if they had heard everything, knowing that, he had these suspicions, they were not confirmed at that time, but, he had tried, even though, and he had tried to contact Department of Social Services, he had tried to do these things. They still felt that the murder conviction was appropriate.
Well, hey, look, he was in her house in the same place where law enforcement found all these incriminating images and footage. How about just steal the computer?
Well,
Right? How about just steal the flash
what
drive?
do you think he probably didn't know that they had taken
Well, I
pictures?
know, but that's what I would
I
argue. Like,
mean,
do things like that. How about,
well,
whatever?
but break into her house and steal her flash drive, I think maybe, I mean, the question was never answered. Did they contact the school counselor? Did they contact a physician? Did they contact you know, or primary care physician or a psychiatrist to maybe ask this child, about the suspicions that they were having about the things that were going on in her life? We never heard any testimony, so we don't know.
Right, right.
Yeah, I mean, his whole story about growing up in Virginia and his parents adopting five Russian kids, and one of the adopted children, Grace, apparently had the same characteristics he thought of Parcells. Man, that's really stretching it to get to the point that he ought to go kill
Yeah.
Yeah.
her. Yeah,
And
and
also,
so
the
yeah,
the prosecution made the point that he'd only seen the daughter 5 or 6 times and only like a couple times in person.
yeah. I mean,
Right.
yeah, let me just say this: there's a lot that we don't know in this case.
Yes.
By that I mean, we obviously knew that this Mr. Mello, Mr. Mello was the
John,
father of the child, right?
Yes, John
Yeah,
Miller.
Yeah.
yeah, yeah, yeah. He met her as an older guy at some cigar bar downtown. What were the circumstances of he meeting her? Did he meet her in
We,
her role as
I,
a call girl? I mean,
we
how did all this take place?
We don't know. And we talked about this in our last episode, this affidavit with this former firefighter who passed away before the trial started, had submitted this affidavit that he sees this ad that John Mellor placed on Craigslist with pictures of her saying, does anyone know this woman? It says her name and also an alias that she used. And like, okay, what are the chances that this guy was just looking? So that clued into me that there's probably, yes, you're correct, a lot of information that we don't know. What are the chances that this guy really just was looking on Craigslist and sees this picture and says, yes, I know her and she solicited me for sex?
Yeah, I mean, I'm not saying he did. We don't know, but I mean,
Yeah, we don't
the,
know.
the,
He's,
the, the whole, and then the second guy was it Post?
yeah,
Yeah.
Bradley
Yeah,
Post,
the
the
post.
the
Yeah,
fiance.
yeah, yeah, yeah. The second guy too. I mean, he was in. Obviously now he's in an orange suit and chains.
Right.
And he's been charged with being involved in all this stuff. I mean, the whole question is, what did they all know at various times? What did they
Right.
know about her? What did they know that she was really up to? And how did that all happen? And how did all that end up in the mind of Zachary Hughes?
That would be
Uh,
my one other question that I would love to know is the relationship between John Mello and Zachary Hughes. How did it become so close so quickly? Like it was less than a year. I think he knew him
You
and
just got this
flew
feeling
to
that
Italy for like 5 weeks together. And they're sharing all these deep thoughts and they're like really tight. And then he's not going to, I want to make sure the daughter stays with Mello. But then he says during the trial that Mello offered him money, which means that he'll never be with his daughter, maybe. What was that Svengali kind of situation where he was able to get this young guy to go kill a woman?
it seemed like a master manipulator to me. I mean, like that was the impression I just got through the testimony and also just reading some of the information about him, that maybe he is somebody who is able to manipulate people. possibly.
Well, yeah, and what we heard is, everything around the murder and what they found afterwards. And you guys are exactly right. My point also is there's a whole other undercurrent of
Yes.
stories of how this all came about and happened.
Yes.
And
And there's kind of a cigar bar connection and all this other stuff.
yeah, and and he's outside. Who's he calling outside? Post in the
Right.
front.
Oh yeah, right
Right.
after the
Right.
exactly. He's on the phone. I mean, I think he actually I think he testified he called his lawyer. So his first instinct, he sees his fiance brutally murdered. I mean, it sounded like he had his lawyer on speed dial all the time. So
Well, that's possible.
I mean, I guess maybe you think, well, I could be in trouble. Maybe it's not a terrible instinct, but I don't know. It's just, if you listen back to the 911 call, he also doesn't really show a tremendous amount of emotion when he's just found his fiance brutally murdered.
And then we also have the biker thing that comes up. He's a biker and a wannabe biker, and somebody threatens to beat him up. And
We heard it all, but we still don't, we heard much more than what the jury heard, but we still didn't hear everything that's happening in this case.
Yeah, and by the way, we may never know, and
Right.
it's all just conjecture. We don't know for
Yeah.
sure, but man, oh man, with all these relationships and all these guys and meeting her the way they did and being, somewhat older and having so much information about her, you sort
Yeah.
of wonder what's going on and how did, this concert pianist, Zachary Hughes, somehow get tied up in all this? I mean, it
Yeah.
is absolutely crazy, this whole case.
I've said from the get-go when I saw how many texts and emails were exchanged, I'm like, that's not normal between buddies. I mean, there's something that it's just that struck me as there's no way I send that many emails to my buddies. There was some sort of either platonic love or something going on there because that's just not a normal buddy
I
thing.
didn't find that crazy. I sent
It's
a lot. I did not find it crazy, I will say, Dad, when I was talking to some of the media during breaks, I was talking to Pretty Little Lies and Alibis, and I said, is this like, have you ever seen anything this wild? And she said, this is the craziest day, the day he testified, that I've ever seen myself. Like she attended Vallow, she attended P. Diddy's arraignment hearing, and she said this was the craziest day.
yeah.
That's interesting. Well, we'll see what happens. I mean, I don't know what the relationships were between Hughes and Mello and all these guys, but man, there's a lot more deeper story that
Oh
goes
yeah.
on here. So what was taking place and what was happening here. I mean, to tell, like, I don't know how long Hughes was on the stand, but to simply tell a story that he was playing outside and he played a nice song for the
Yeah.
guy's daughter, and they struck up a friendship, and because he had this issue with his
Adopted sister.
adopted sister, that somehow he saw something there and he saw something that wasn't right and he was going to go right it and he wouldn't kill her. And clearly Mello knew about it based upon, I gather, or it seems like he knew about it based upon the nature of the texts going on with them right afterwards.
Yeah.
And so, the whole thing is absolutely crazy. I've seen, I don't think I've seen a case like this, honestly. I mean, I thought the Murdoch case was over the top a little bit.
Yeah.
Murdoch's case looks like a hit and run accident,
Right.
It really does. It really does. This one is for sure like just a lot. I thought it was a lot crazier.
Yeah. But as always, Professor Matt, we appreciate it. Enjoy the rest of your vacation.
Good. It was just good.
Great.
Perfect.
Absolutely.
Good.
Thank you,
Thank
sir.
you so much. Glad to help out, guys. Thank you.
Talk soon.
Okay,
See you next
goodbye.
week.
Bye.
See you next week.
Bye.
Bye.
Your dad always shedding some great light on any of these trial situations we have. So always appreciate Matt stopping by. You've got some comments.
Just a couple of comments on our last episode. Someone asked, does anyone know for sure if Christina Parcell knew what her boyfriend was doing? And the answer to that is yes, because she was in some of the photographs with her daughter. So it sounds like she would have known that. I mean, there's a possibility she was drugged. They're allegations.
Yeah, because nobody's seen these yet. These are just
No one. Well, they were
rumors.
described in legal documents.
Okay.
They were described in legal documents. There were some descriptions, very disturbing. Again, but we don't know for sure if she was possibly drugged or something along
Or
those
also the
lines.
extent. We don't know the extent that she knew. Like, did she know everything Bradley Post was about to be charged with? Or did she know just that he took pictures of her? I think that all that'll come out, I would imagine.
That is a trial I would not be attending. Also, someone asked the question, does anyone know who has custody of her daughter? And I don't know the answer to that question, but I was told that she is in a safe, good place.
Okay. There you go. It is a crazy story, but obviously the big hope is that daughter gets all the help and love that she needs.
Absolutely.
Impact of Influence on Facebook. Also, the YouTube channel would really help us if you'd rate and share and subscribe to the YouTube channel. And we'll talk soon, friend.